Good evening, everyone. Good evening, everyone. I'm Rohan Parulekar, Senior Vice President, Indian Venture and Alternate Capital Association. On behalf of IVCA and Grant Thornton, a warm welcome and thank you for joining at such short notice for this important discussion on the Supreme Court's ruling in the Tiger Global Flipkart case. Over the last few days, this judgment has become a focal point for global and domestic investors alike because it goes to the heart of how India views treaty entitlement, substance, and the taxability of offshore exits in India focused structures. The court has upheld the tax department's stance that capital gains on Tiger Global's Flipkart exit are taxable in India, and that treaty benefits under the India Mauritius DTA can be denied where structures lack real commercial substance and fall foul of GAR. For venture capital and private equity funds, this raises immediate questions as to how should existing holding structures be evaluated? What does this mean for grandfathered investments and TRCs? How will this influence deal making, secondary sales, and exit planning going forward? At the same time, India remains a critical growth market, and policy stability and predictability are essential for sustaining long term capital flows into the startup and innovation ecosystem. As the Apex Association representing alternatives in the country, as IVCA, the endeavor is twofold. First, to facilitate a clear technical unpacking of what the judgment actually says and what it does not say. And second, to channel industry feedback in a constructive manner to policymakers so that guardrails against abuse can coexist with a competitive, welcoming investment climate. So today's conversation is meant to separate signal from noise, to move beyond headlines, understand the reasoning of the court, and think through practical implications and risk mitigating steps. With that, I would like to invite Mr. Riaz Thingna, partner at GT Bharat, to come over and welcome the other panelists as well as moderate the session. Over to you, Riaz. Thank you.
Thank you. Thank you, Rohan, for this introduction. And good evening, everyone. And again, a warm welcome to Thornton Bharat's webinar dedicated to the recent Supreme Court ruling in the Tiger Global case. This evening, we'll be exploring the nuances and implications of the landmark decision. I'm Riaz Thingna. I'm partner at Thornton Bharat, specializing in both domestic and international tax advisory and regulatory services. In this period of major global events, some concerning, some scary, and some plainly humorously ridiculous, your decision to spend time with us on this taxing matter is truly appreciated. Tonight's discussion centers on the Supreme Court's pivotal decision in the Tiger Global case, a topic that has kept us thoroughly engaged over the past week. This is a landmark judgment of the Supreme Court, which has laid down some important principles which shall reshape the application of tax treaties in India. The Supreme Court has ruled that a tax residency certificate functions only as an eligibility condition and is not a guaranteed gateway to treaty protection. It is critical to establish commercial substance, residence, and effective management. It has also given some extra teeth to the revenue by stating that the tax treaty cannot be invoked to override an impermissible avoidance agreement once GAR is invoked. Judicial anti-avoidance rules also enable the revenue to disregard structures lacking commercial substance. While the decision reiterates that taxpayers are free to structure their affairs, it equally stresses that such arrangements must be anchored in law and supported with commercial rationale. Overall, the judgment gives a decisive trust to substance over form, residence and control scrutiny, and anti-avoidance alignment. To help us unravel the intricacies of this judgment, I am delighted to be joined by an exceptional panel of experts. We have Mr. Pramod Kumar, former member and Vice President of the Income Tax Appellate Tribunal. Mr. Kumar has authored over 15,000 judgments during his distinguished career and has served as Director of the International Association of Tax Judges. With more than 23 years of experience in direct and international taxation, It is an honor to have him share his insights with us. Welcome, sir.
It's a pleasure.
We also have Ms. Richa Soni. She's a seasoned tax and regulatory specialist with over 25 years of experience, renowned for her clarity and ability to simplify complex tax matters. Richa brings invaluable expertise to our panel. Welcome, Richa. It's a pleasure having you here.
Thanks, Rehas.
Finally, we have Ms. Aparna Khatri, chartered accountant with more than 2 decades of experience advising multinational groups on intricate domestic and international tax, as well as transfer pricing issues. Aparna's holistic, business-focused approach distinguishes her as a trusted advisor in the field. Welcome, Aparna.
Thank you so much. Good evening, everyone.
We hope to make tonight's session engaging, insightful, and thought-provoking. Please feel free to submit your questions via the chat box. We'll address as many as possible during the webinar. And for those questions that we can't cover, we'll be sure to respond by email afterwards. So with that, let us begin our exploration into the Supreme Court findings. To set the stage, I invite Aparna to provide us with a broad background and highlight the key aspects of the case. Over to you, Aparna.
Thank you so much. Hold on. So we start with the brief facts of the case. The idea is to focus less on the factual matrix here, but more on the takeaways. So we'll keep the facts, the discussion on the facts very crisp. So we are dealing with three taxpayers over here. Tiger Global International. Three entities are there, which are Mauritius-based entities. The taxpayers are Mauritius-based private companies. They hold Category 1 global business license, and they also held valid TRCs issued by the Mauritius revenue authorities. These entities were set up with the stated objective of undertaking investment activities for long-term capital appreciation. The taxpayers were advised by another group entity, Tiger Global Management LLC, which was a US-based entity. In a span of three and a half years, between October 2011 and April 2015, the taxpayers acquired shares in Flipkart Singapore, which in turn derived substantial value from assets located in India. In August 2018, as part of Walmart Inc.'s global acquisition of Flipkart, the taxpayers sold their shareholding in Flipkart Singapore to a Luxembourg-based entity for a consideration of approximately USD 1.6 billion. This sale transaction is what is forming the crux of the dispute here. If we quickly move on to the way the matter has progressed across various authorities, the taxpayers filed an application for a lower withholding with the assessing officer. The AO got into the facts of the case and he declined to grant treaty benefits to the taxpayer. It was alleged that the taxpayers lacked commercial substance in Mauritius and the effective control of the taxpayers was outside Mauritius in the US. Disagreeing with this outcome, the taxpayers then went on to file application before the Authority for Advanced Ruling, or the AAR, to seek adjudication on the matter. The AR followed the steps of the AO and they refused to admit the applications at the threshold on the basis that the taxpayers were effectively controlled from the US and that they lacked commercial substance in Mauritius. With the rejection of the applications, the taxpayers went on to challenge this order before the Delhi High Court. The Delhi High Court reversed the decision and ruled in favor of the taxpayers. And it held that the possession of a valid TRC and the satisfaction of the limitation of benefits clause or the LOB provisions was sufficient and was met in this case. There was no fraud or treaty abuse to deny the benefits. So as these conditions were satisfied in the present case, the High Court ruled in favor of the taxpayers. The revenue authorities then challenged this ruling of the Delhi High Court before the Supreme Court. The Supreme Court, as has been already mentioned by the other panelists, has overturned the High Court's judgment and has upheld the AR's position. So basically, the Supreme Court has upheld the judgment of the action of the AR to reject the applications filed with the taxpayers. We now get into a little bit of nuances where we discuss the rulings of the respective authorities. We first start with the AR. So the AR looked at the structure and the facts of the case. It went beyond the formal structure and examined where the management and control of the taxpayers actually resided. The AR stated that the overall control and management of the Mauritian entities was not in Mauritius. They went through a lot of information which they thought was relevant to determine that the control and management of these entities was sitting in the United States. They looked at aspects such as the authority to operate bank accounts for transactions beyond prescribed thresholds or whatever agreed thresholds was vested in an individual who was who was a US party. They said that while investment and divestment decisions were formally approved by the board of directors of the taxpayers, the real decision-making control, especially for substantial transactions, was exercised by a particular gentleman, Mr. Coleman, through a non-resident director, Mr. Stephen Boyd. So, in a nutshell, the AR observed that concluded that the head and the brain of the taxpayers was not in Mauritius, but in the US. Against this background, the AR stated that the object and scope of the India-Mauritius DTAA was to grant capital gains tax exemption in respect of transfer of shares of Indian companies, and that such benefits could not be extended to gains arising from the transfer of shares of a Singapore entity. The AR further stated that a holding structure by itself was not determinative. However, when viewed together with the prima facie absence of management and control at the Mauritius level, the structure assumed relevance in assessing whether the arrangement was designed for tax avoidance. On an overall evaluation, the AR concluded that the transaction was structured with the intent to derive treaty benefits not contemplated by the lawmakers, and it amounted to an arrangement for tax avoidance in India, and accordingly they rejected the applications. Aggrieved by this, the taxpayer travelled all the way to High Court, challenging the ruling of the AR. The Delhi High Court granted relief to the taxpayers and reversed the AR ruling. In doing so, it's important to note the High Court acknowledged the treaty partner's intent and the CBDT's express clarification that a valid TRC and LOB compliance suffice to access treaty benefits in the absence of a fraud or abuse. In particular, the High Court observed the following. The first observation was that the Mauritius route has historically been a legitimate and attractive jurisdiction for investors into India, owing to its geographical proximity and India's treaty framework. The court observed that the mere domicile in Mauritius does not by itself justify suspicion or a need for meeting a higher threshold of legitimacy. On the issue of beneficial ownership, the court clarified that the concept would become relevant only when the holder of the income has no real control over such income and merely acts as a conduit under instructions to pass the income on to another entity. Then the court went on to analyze the commercial substance of the structure. The court noted that the taxpayers were set up as pooling vehicles for investments. They held a valid Category 1 global business license, and they satisfied the expenditure thresholds prescribed under the LOB clause. The mere fact that the parent entity exercised shareholder influence would itself not be sufficient to characterize the Mauritian entities as mere puppets. Please excuse me for a minute. Please pardon the disturbance that some. Sorry. I'll just continue. Yeah, sorry. On indirect transfer, the Delhi High Court disagreed with the AR's approach. The grandfathering of capital gains on transfer of investments in shares of an Indian company made before 1st of April 2017 would also apply to the transfer of foreign company shares that derive substantial value from assets located in India. Importantly, the Delhi High Court upheld the sanctity of the TRC, noting that the CBDT and the Finance Ministry itself had clarified that a TRC issued by Mauritius authorities is sufficient proof of residency. Finally, on GAR, the court held that Chapter 10A was inapplicable in light of the express grandfathering under Article 13(3)A for acquisitions made prior to 1st of April 2017. The court also noted the clear intent of the contracting states to ring-fence such transactions, not only by way of what was there in the treaty language, but also by way of Rule 10(u)(1), specifically Subclause D. Now, the revenue authorities challenged this ruling before the Supreme Court. What we will discuss here are, so while there are many observations in the ruling, we will focus our energies on certain important findings which will have a larger impact. We've kind of broken it into 3 pieces. The first piece deals with the validity of the TRC. So we are all aware that the pattern of investment flows into India and their concentration among a limited number of treaty partners. The cross-border investment structures into India were historically established in good faith, based on certain settled principles. They were widely accepted in practice and consistently followed both in practice as well as upheld by various judicial proceedings. The first principle was on the residency-based taxation. Where an investor demonstrated treaty residency, the allocation of taxing rights under the treaty were honored. Second, the validity and sufficiency of the TRC were respected. Even in cases where the government consciously knew that this could have led to a perceived tax leakage, because certainty and predictability was seen as critical to attracting much needed foreign investment. This approach, as I mentioned, was already acknowledged and blessed by various rulings because it was in the larger interest of the country. More specifically, the Supreme Court recognized treaty shopping, per se, if we so call it, as a policy choice to attract foreign capital. In Azadi Bachao Andolan, it upheld Circular 789 and affirmed the government's power to issue treaty implementing circulars. In the case of Vodafone, the Supreme Court held that a valid TRC cannot be disregarded except in cases of fraud, sham, or colorable devices. Then comes the amendments made to the Finance Act 2012. There were three critical amendments which the Supreme Court spoke about. The first being in Section 9, where indirect transfers were introduced. Second was GAR provisions introduced, and the third one was the changes made to Section 90 to limit the powers or the validity or the importance granted to TRCs. The court said that Section 90, subclause 2A, limited the treaty override powers. It made treaty override under Section 90, subclause 2, subject to GAR. Next, the court held that by virtue of subclauses 4 and subclauses 5 to 90, TRC was made a necessary but not a sufficient condition. There were other prescribed information and documentation which was required to be submitted by the taxpayer. In conclusion, the court said that the law has evolved over a period of time, especially citing the rulings of Azadi Bachao and Vodafone, and they said that there were amendments to the law itself, and because of which there is a limited validity of the CBDT circulars that the assessee was relying upon. The court mentioned that the CBDT circulars are binding only within the legal regime in which they are issued, and they cannot override subsequent statutory amendments. Here, there is one point that I would like to draw attention to is there is a lot of discussion in the ruling on India's sovereign right and duty to protect its tax base. This will be taken up by the panelists later, but when the TRC was being discussed and the powers of Indian authorities to look beyond the TRC issued by another government, there's a lot of discussion on sovereignty of India's taxing. Lastly, the court held that the TRC is only an eligibility condition. Its possession does not bar either the revenue authorities or the courts from examining treaty eligibility or abuse in case of tax avoidance. The next issue is on indirect transfers. While I did not get into the question that was there before the Supreme Court, the key question that was framed by the Supreme Court was whether the action of the AAR in rejecting the applications of the taxpayer was correct. I've just summarized it. It's a rather long question in the judgment. But the bottom line one was whether the AAR's rejection of the application was correct. However, in the judgment, we find certain observations given in the context of indirect transfers. This will be discussed by the panelists. I just thought to capture them as well. So the Supreme Court in the context of indirect transfers seems to have adopted a restricted construction of Article 13 of the India-Mauritius Treaty. The court held that the grandfathering of investments made prior to 1st of April was restricted only to cases that squarely fell within the purview of Article 13(3)(a) of the treaty, which deals with shares of an Indian company. Further, for the purposes of claiming exemption under 13(4), the court clarified that it is not sufficient for the assessee to merely establish residence in Mauritius. The assessee must also demonstrate that the movable properties or shares in this case are directly held by it. In the absence of such direct holding, the Supreme Court said that the capital gains arise in India and hence they are taxable in India. There is one important observation in this ruling, which the panelists will discuss, is that the Supreme Court has observed that an indirect transfer of shares does not, at the threshold, fall within the treaty protection contemplated under Article 13 of the treaty. There is an interesting observation, another one here. The court further stated that the object of the DDAA is to avoid double taxation and not facilitate double non-taxation or tax evasion. Treaty benefits therefore would be available only where it is established that the transaction is taxable in the state of residence. So this is one important observation which will be discussed. The court said that the 2016 amendments to the treaty, where the India-Mauritius Treaty was revised, were also viewed as reflecting an express intent to prevent revenue loss in the source state arising from the abuse of treaty provisions. The last issue that we would like to touch upon, which the Supreme Court has dealt with, is the interplay between jar and gar and whether they can be invoked at the same time in a given structure or in a given transaction or an arrangement. Before we get into the interplay, it is important to understand what is the difference between gar and jar. I'll just keep it very simple. So GAR, or the General Anti-Avoidance Rule, is a statutory anti-avoidance framework that empowers the revenue authorities to declare an arrangement as an impermissible avoidance arrangement, where the main purpose is to obtain a tax benefit and to recharacterize, and then the tax authorities can recharacterize the arrangement accordingly. JAR, on the other hand, refers to judicial anti-avoidance principles which have evolved through guidance given by the courts in case laws. These have been around for quite some time, and they are grounded primarily on the doctrine of substance over form. On the issue of applicability of GAR, the Supreme Court has reaffirmed that India's tax avoidance provisions are relevant when evaluating whether treaty benefits would be available. In the facts of the case, GAR was held to be applicable, thereby empowering the revenue to examine the arrangement and, if warranted, declare it to be as an impermissible avoidance arrangement. The court further said that while the Act provides for grandfathering of investments made prior to 1st of April 2017, the court said that this grandfathering is not absolute, it's not sacrosanct. The court held that a combined reading, and I'll get a little technical over here, there are two rules which are at interplay over here, is Rule 10(1)(d) and Rule 10(u)(2). 10(u)(1)(d) deals with investments which are protected from GAR, which are made prior to 1st of April 2017. Rule 10(u) deals with arrangements on which GAR will apply. The court said that the combined reading of these two rules indicates that GAR can be invoked in respect of any arrangement, irrespective of when it was entered into, so long as a tax benefit is obtained on or after 1st of April 2017. The panelists will shed more light on this. I just captured the gist of what has been said. The court further said that the prescription of a cutoff date under 10(u)(1)(d) therefore stands diluted by 10(u)(2), where a tax benefit is derived, and the duration of the arrangement in the court's view was irrelevant for this purpose. Significantly, the Supreme Court also accepted the revenue's contention that where GAR is held to be applicable, assuming that in this case GAR was not to be, could not be applied, but still the authorities could have invoked JAR and then accordingly they could have questioned the structure. To sum up, the Supreme Court noted that the taxpayers had sought exemption under both India and Mauritian law. The court found that this was not in accordance with the intent of why the treaty was entered into. It is not in sync with the spirit of the treaty. The Supreme Court held that this entire structure justified denial of treaty benefits on the basis of an impermissible avoidance arrangement. The court reiterated that while legitimate tax planning is permissible, exemptions cannot be sustained where the underlying objective is treaty abuse. The court held that the lawmakers had statutorily empowered the AAR to reject applications at the threshold where a transaction appears to be prima facie tax avoidant. The use of the expression prima facie was held to indicate that the AAR did not need to undertake a very detailed examination. It is sufficient if on a preliminary scrutiny or an initial scrutiny of the documents, the AAR came to that conclusion. Accordingly, the Supreme Court ultimately upheld the AAR's decision to reject the taxpayer's application. This kind of sums up the journey of this matter till date. I will now hand it over back to Riyaz to deliberate on the observations of the Supreme Court and how does it impact us at large. Thank you so much.
Thank you, Aparna, for an excellent presentation, laying the broad facts and the broad principles of the judgment. Now, getting right into the discussion, Pramodji, let me start with you. The Supreme Court, in its concluding paragraph of the verdict, has stated that the taxpayer would not claim capital gains exemption under Article 13(4) of the India-Mauritius Treaty, as a transfer of unlisted shares was carried out pursuant to an arrangement that was impermissible under law. The court stated that once it is factually established that the transaction was structured for tax avoidance, the assessee is not entitled to benefits under Article 13(4). The Pramodji, in your view, now are indirect transfers outside the tax treaty benefit post this decision?
Well, I'll answer it this way, that there are certain observations in the Honorable Supreme Court judgment which give a reasonable apprehension to the stakeholders that the indirect transfers and the benefit from the gains from indirect transfers are outside the ambit of the treaty protection. But then you have to take these observations in its context and subject to its limitation. Let's see the bigger picture. What the court has said is that they are not entitled to the treaty benefit. And then they've discussed the analogy of what is covered by Article 13, Sub-Article 2, and then extended it to 3, 4, etc. But please understand, the treaties are not a benefit regime or an exemption regime. This is an allocation of taxing rights. Now, if there is any income of a resident of one contracting state in the other contracting state, it has to be classified under some head. What the court seems to have proceeded on the basis is that there's a benefit or exemption envisaged and you are not fulfilled the condition. That really is not the scheme of the treaties. If an income is not covered by Article 13, then what happens to it? Can somebody get that slide which I had sent you about the impact of this? First of all, the observation that it's not covered by the scheme of 13 seems to be slightly at variance with how it's the next slide, please. How this scheme, how the scheme of the article is understood. Because 13(4) is a residuary head. And whatever doesn't fall in 13(1), 2, 3, etc., automatically goes to the residuary head. Now, if it's a capital gain and it does not fall into those specific head, it automatically gets into residuary head. And if it doesn't even get into residuary head, as has been said by this or indicated in this judgment, or probably that's one of the interpretations in this judgment, then where does it go? If there's an income of one of the residents in a contracting state, in the other contracting state, it is to be characterized in one of those articles, right? Because that's how taxing rights are allocated, and to that extent, tax sovereignty is ceded. Now, if an income is not in the capital gains article, not covered, as probably is the impression, then where does it go? Does it go to the residuary head, which is other income? Now, one school of thought would be that it would not fall even under the residuary head, because residuary head is not an income which is not taxable under the other heads. It's an income not dealt with by any of those provisions. So can we say capital gains are not dealt with by Article 13? Answer is no, because these are dealt with, but a particular kind of capital gain is not covered by it. So if it fails the test of taxability under Article 13 or test of coverage by Article 13, it fails the test of taxability. You cannot bring it under Article 22 also. That's how the courts have understood the scheme of the treaties. I myself wrote a decision way back in 2013 in the case of Andaman Food Product, where this principle was highlighted. And the proposition laid down was that if there is a kind of income which is covered by an article but is not taxable under that article, that is the curtain so far as taxability of that income is concerned. So one proposition will be, here are capital gains which are not covered by Article 13, so they can't be taxed in any other head. For example, in FTS, a fees for technical services which does not satisfy make available condition. If it is not covered by Article 12, in that case, it cannot become taxable as another income. Take, for example, a business income, in which case there is no permanent establishment. So if it cannot be taxed under Article 7, that's the end of taxability. By the same logic, it cannot be taxed under Article 22 either. Therefore, the net result of this observation, to my mind, would be something which is most unintended and which was nobody's case. I do not think revenue at any stage said that these are not treaty protected. And rightly so, because when the provisions for indirect transfers were introduced, and that was way back in 2012, the finance minister expressed this on the floor of the House that it will not affect the treaty partner jurisdictions. And that is something which is very well noted in the Honorable Supreme Court judgment in para 12.19, if I'm correct. They have specifically noted this finance minister's assurance. So you cannot proceed on the basis that this will affect them. And the only way it doesn't affect them is it doesn't disturb the scheme. Now take the other possibility that no, it's not taxable under Article 13, but it is taxable as other income nevertheless. That leads to even more dangerous consequences, because there are certain treaties that India has where the residuary rights are given to the resident states. For example, UAE, for example, Korea, for example, prior to amendment of the treaty, it was in Mauritius also. So are we suggesting that in all those cases, the indirect transfers will not be taxable if the person transferring these shares is a resident of UAE or Korea or some other country where the residuary rights are given to the residence jurisdiction? That also leads to a conclusion which doesn't really work out. And I'm afraid if this interpretation is to go to its logical conclusion, revenue has to lose much more than what it seems right now. There'll be no indirect transfer which will be taxable anywhere in any treaty partner jurisdiction. So that I do not think the scheme of the act. And then this was not the question before their lordships. What they have said is they have made some observations. And if you really see the genesis of this observation, that is in the last paragraph of the AR ruling. If you see AR ruling, I think paragraph 48 that is, in paragraph 48, towards the end, AR has somewhere mentioned this particular proposition that no, it's not entitled to the benefits. But please understand, treaties are not a scheme of benefit. Treaties are allocation of taxing rights. And if there's a taxation, somebody has to have a right for taxation of that amount. And if somebody has to have taxation, it has to fall under those income characterization articles. And if it doesn't get into any article, it's not taxable at all. That's not the scheme. So I would think that the way these observations are given is one thing, but the way it is to be understood, bearing in mind also the fact that it was not an issue to be decided by them. And to the best of my understanding, it was never the revenues case that an income from indirect taxes is not covered, indirect transfers is not covered by capital gains. And if it was their case, it was contrary to the statement which the Honorable Finance Minister made on the floor of the House. And this very judgment talks about contemporaneous expositio. What can be better contemporaneous expositio than the understanding of the Honorable Finance Minister who was moving that amendment? So, to my take would be that yes, there are observations which give this legitimate apprehension, but when you look at the bigger picture, that's not how the scheme of the treaties is, and that's not how it's likely to be construed. Now, what can happen from here on is, I would imagine maybe CBDT takes some step, and CBDT has done it in past. Remember when Kulangan Chettiar judgment came and the word may be taxed was interpreted in a manner which turned the India's tax treaties into exemption regime, which was not the scheme. Then there was a notification under Section 90, which said, no, maybe tax means this. So similarly today, there can be a simple issuance of notification by the CBDT in exercise of the powers they have under Section 90, and they can clarify that capital gains includes indirect transfers. Once that happens, that brings an end to this controversy. And I think that's what is probably logically going to happen.
Great, Pramodji, that I think you've raised some very, very important issues. And I think the context that you said really requires some intervention from the CBDT to put the issue at rest. Thank you for that. Richard, coming to you now, for a long time, a tax residency certificate was considered as sufficient proof to claim treaty benefits. Now the court has characterized the tax residency certificate as merely an eligibility condition and not conclusive proof of treaty entitlement. Now, what would you say are the practical implications of this?
So Riaz, here, as you rightly mentioned, what they've said is that it's not a guaranteed gateway to treaty relief, and TRC is not binding on the tax authorities or courts, and they have to do their independent validation to see whether at all the parameters and mainly, the residency and substance parameters are met before they grant this relief. So one is, of course, we see that there is going to be an increased scrutiny by tax department on this front. Also, on the practical side of things, while this decision is in context of capital gains, but the principles laid down here can be very easily extrapolated to the other payments, the other routine or the regular payments, as we would call them, maybe the interest, the dividend, and the royalty payments. Now, typically, what has been done so far is that the payer would look at the TRC, they would seek a no P declaration, a 10F if required. We'd look at the agreements for income characterization and then make the payment, determining what is the withholding tax rate. With this, there is an apprehension that now is there a need for a little bit of more due diligence required, and if it is required, then to what extent? So, generally we've seen that in any case, payers try and take conservative positions. So, does it mean that, with this, if there's no guidance on this one, they would probably stick to the domestic tax rates, or, there will be a over reliance on the certificates issued by the tax authorities, the nil withholding or the lower withholding certificates, if they want to play it safe? So, to my mind, there may be a requirement for a CBDT clarification on this, that if at all the regular payments are to be made at this juncture, what is it additionally that they would want the payers to comply with? What is the extra due diligence that is required? That I think will clear a lot of air on this aspect.
Yes, and very rightly, as you mentioned, it will be extremely difficult for payers to, take their normal business decisions, and it can put a lot of onus on and responsibility on them. So I think clarity on this issue is extremely essential. And Pramodji, then coming back to you, were the circulars on TRC, were they benevolent circulars? What is the court's view on this?
Yeah, sure. I'll come to that. Before that, I'll just supplement what Richa has said and make one small point. And that is with respect to the conduit companies and how this, treaty abuse is to be addressed. Now, if you recall that from 1977 onwards, in 1977, first time beneficial ownership concept was noticed by the OECD, by the multilateral bodies. And that came in the context of the report on the conduit committees. So, and the way it has been construed, particularly in Indo-Food case in the United Kingdom, very strictly, and they have said we'll go by the international fiscal meaning. So if the concept of beneficial ownership is applied strictly, I think that problem is very considerably addressed. I think the problem is that in some of the judgments, the concept of beneficial ownership has been used in a very, I would say, perfunctory manner or very kind of superficial manner. Take some Canadian decisions, for example. And then even in Alta Energy, it went up to the Supreme Court of Canada, where Chief Justice was in minority. And there was a 6-3 judgment in favor of the taxpayer when they were talking about beneficial, not really beneficial ownership. It was in the context of GAR, but beneficial ownership had a role to play there. So, and in Indian tax treaties, you don't find the concept of beneficial ownership in Article 13 anywhere. I don't know of any treaty. I'm particularly sure that in Singapore Treaty, in Mauritius Treaty, you don't have that concept. So what was needed to be addressed by strengthening the beneficial ownership part has sought to be addressed by the basic entry requirement, and that in a way is quite justified. Now coming to the second question which you asked me about the circular. Yes, it was a benevolent circular. Please recall the context in which it was issued. It was issued on a day when Sensex fell by almost 10%. And that very day, I think the next day, this circular came. There was a widespread apprehension in the market. If you remember the context, the day on which this circular was issued. So it was a kind of a benevolent circular. The question is, when does a benevolent circular cease to hold good? Now, there are 3 or 4 situations. One situation, when you withdraw it, very simple. Government did not do that. Second, when it becomes inconsistent with the provisions. And when I say the word inconsistent, I would say that even if it's a circular under the old act, it will continue to be valid unless it becomes inconsistent. And one example of its becoming inconsistent, which comes to my mind, is when Section 1014 was amended in 1989, and the exemption of allowances was related to notifications. That was the point of time when all earlier circulars ceased to be valid. And unless there was a notification, it would not work. Now, the question is, in the present case, did it become inconsistent? And yes, there are 2 more situations. Another situation is which is when we said by a 5-judge bench in Ratan Malting's case, where they said if a circular is contrary to the law laid down by a constitutional court, it ceases to be valid. So today, when the law is laid down by the Honorable Supreme Court in Tiger Global, even if they issue a circular, that's no good. Forget about the old circulars. The question is, and of course, there are situations when the circular is not in accordance with the law, so you have varying perceptions on both ends of your decisions. As on today, this circular is not valid for the short reason of Article 141 law being declared and in view of Ratan Malting. But yes, it was a benevolent circular, and until this judgment came, there could be a school of thought that it was valid. The court has said it was an old regime. So simply being an old regime is not good enough. It has to be inconsistent. Now, can you say that because of Section 90, subsection 5, it is inconsistent? Section 90, subsection 5 says, yes, additional papers may not be required. But someone in the CBDT says, no, it's not, you don't worry about it, we'll not ask you for it. So that seems like a kind of a liberal or literal interpretation, but all that is academic today in view of what the Tiger Global has said and what the 5-judge bench in Ratan Malting's case is.
Well, thank you, Pramodji. But then extending this, can we say that this ruling is only in the case of context of Mauritius rule? Or could the reasoning now be applied to tax treaties with any other country, Singapore, Cyprus, Netherlands, whatever?
What they have held is with respect to the tax treaties. And there's everybody is concerned about the talk of tax sovereignty. But please understand what is this talk of tax sovereignty. The idea is in a tax treaty, you cede the taxing, cede your tax sovereignty only to the extent it is agreed. For example, somebody could say that you have brought Section 90, subsection 5, so you're asking me more about my genuineness. Can you do that? No, that I have not ceded. On anti-abuse law, I have not ceded. That's all the court has said. So once the court is of the view that even when you cede your tax sovereignty in a tax treaty, it is only with respect to that income, and anti-abuse provisions will remain out of that area which is ceded. I think it would apply to every treaty. But that would primarily be the portion when you talk about the treaty entitlement. And as for the other issues, I think there are some reservations. The first time I touched the treaty was 32 years ago. But I can tell you, I could not think of one argument to support this judgment when it comes to the interplay of Article 13.2 and 13.4, etc. So maybe it's my limitation, but I do not know what is the argument available for this.
Great for that frank opinion, Pramodji. Richa, on the practical side, what happens to old cases? Would they be reopened? Are we looking at aggressive action from the revenue side? What do you see? How do you see the situation on the ground?
So, Riaz, there are some media reports which say that the CBDT has confirmed that the past cases will not be reopened. However, there is currently no formal communication or press release which has been released by CBDT so far. So, to my mind, just to calm the nerves of the investors, if a formal communication from CBDT can come, that will be really useful. And just another aspect is that, post introduction of statutory guard, in any case, it's not something that the substance was not being examined earlier. So, in most structures, these factors were already being considered. It's just that now with this decision, maybe a more granular examination is required. Now, a risk assessment here of the existing structures may be very useful if this is carried out in light with the principles which have now been laid down. But there is also a perception and also another view that if you do some tweaks right now, basis, what are the principles laid down in this decision, this can give also a negative perception of your original structure. So I believe these are the things that you would need to balance through where you are augmenting the existing inbuilt measures, or are you introducing the newer ones, keeping in light the principle laid down in this decision?
No, that's a very valid point, because if you review the structure today, it is almost, it could be interpreted as an admission of something not being passing muster in the old structure. So that could be a risk one is taking. And I take your point that some clarification that old structures are not going to be reviewed will definitely calm nerves and ensure that the investment climate is not badly disturbed. Pramodji, coming to you again, the court's interpretation of Rule 10U2 suggests that GAR scrutiny may still arise where tax benefits accrue after 1st April 2017, even for pre-2017 investments. Does this ruling significantly narrow the scope of grandfathering under Rule 10U1D? What is the difference between investment and arrangement? I mean, there's so many questions.
Before I come to what their lordships have said, let me explain what is the interplay between Rule 10U2 and Rule 10U1D. And if somebody could get that slide. Okay. Now, when it comes to grandfathering of investment, what you see in Rule 10U1D, I'll just read it out. It says, it says any income accruing or arising or deemed to accrue or arise or received or deemed to be received by any person from transfer of investment made before 1st April 2017. So this says your investments prior to 1st April 2017 are protected from application of GAR. Now let's look at Rule 10U2. Rule 10U2 says, and it's so there on the screen, without prejudice to the provisions of Clause D of Subrule 1. That means Rule 10U1D is protected. 10U1D was, we will not touch the investments. The provisions of Chapter 10A shall apply to any arrangement, irrespective of the date on which it has been entered into, etc., in respect to the tax benefit, even after the 1st April of 2017. Therefore, investments are protected, arrangements are not protected. Now, what is the distinction between two? That's critical. Now, first of all, the way this ruling has been given, and if you kindly see the words there, the word there is, when they have said, they have said prescription of cutoff date of investment under Rule 10U1D stands diluted by 10U2. Now, when you say that 10U2 dilutes 10U1D, that cannot be the impact of the words without prejudice to. That's impact of the word notwithstanding. I do not know whether it was an inadvertent omission or inadvertent thing or conscious thing, but it seems that principle seems to be slightly difficult to understand. Now let's understand this structure. If you have an investment, you have made an investment. Investment is also part of the arrangement. But when you draw a line of distinction between investment and arrangement cannot be treated as having the same meaning. To my mind, investment would be when you put the money into something. And arrangement is when you have a structure in place. For example, a US company going to Mauritius and then investing in Singapore and then being taxable with respect to a company which has a substance in India and that's being taxable. That's a structure you have put in place. The way one would normally look at it is that if I make an investment up to 2017, that will be protected. But tomorrow I cannot come back and say, look, this structure was in place from prior to 1st April 2017. So you have to give me the relief in respect of investments made thereafter also. That would possibly have been an argument. No, the investment was already in place when GAR provisions came. So the GAR provision said, no, structure will not be grandfathered. Structure will not be treaty protected. If you see it in this perspective, then you can see a clear line of demarcation between grandfathering the investment and grandfathering the arrangement. Or please use the word structure for a minute, that it would look easier. Just because a structure is in place prior to that date, that would not be protection, your reason for treaty protection. But because the investment was in place, that's reason for treaty protection. That's how it was understood. And allow me to say this, that's how it was seen even in the board circulars. The distinction between investment and arrangement was always recognized. If someone is to say today that there is no distinction because investment is a part of arrangement, I have my reservations on this approach on the first principles. But having said that, that cannot be that cannot affect what the legal position is. Today, the legal position is that their lordships have said that prescription of cutoff date of investment under Rule 10U1D stands diluted by 10U2. My understanding is, and please forgive me for putting it so bluntly, my understanding is that probably without prejudice was seen as notwithstanding or something like this, because without prejudice doesn't lead to this conclusion. But that's the point as of now. Now, unless it is reviewed, unless there's an occasion to review it or to revisit it in a subsequent case, the position that remains today is that investments are de facto not protected because the line of distinction between investment and investment is lost. So if you ask me what the law today is, yes, that's what the judgment holds. If you ask me what I think is more convincing alternate interpretation is, that's something to be decided maybe in a review petition or maybe in a subsequent case. I, for one, have faith in the judicial system, and I also have faith that if we have a legitimate point, Indian judicial system is so strong, and even the CBDT, I would say, today government is so responsive. They have their ears on the ground, and they're ready to take corrective measures in whatever way it's required to be done. So I'll not be surprised either by a review or by a subsequent revisit, and I will also not be surprised by CBDT taking a categorical stand on this matter. I do not know about what precisely were the arguments, but one of the line of argument was that unless we cover the investments also in arrangement, the words made irrespective of gains after this date will become redundant. But that's not true. Once you see it in this perspective, that will not be redundant. And that's why my take is. So law, as on today, against you. I'm an incurable optimist that way. I have reasonable belief that this matter should come up clarification, ideally through administrative mechanism, but also it is possible that it is revisited in the judicial mechanism as well.
Thank you. Thank you very much, Pramod Chief. We are really running short. Richa, from whatever we can see from the discussions so far, would it be fair to state that the ruling indicates that GAR and JAR can coexist, which was not our understanding before? If so, what could be the implications?
So yeah, Arias, there are certain observations of the court which kind of bless the coexistence of GAR and JAR. Now, if we were to look at it from a historical perspective, when GAR was introduced, one of the objective was to codify the substance over form doctrine, which was laid by courts over the past several decades. Now, it was felt that there were inherent limitations, subjectivity in the judge-made GAR, because under similar set of circumstances, two different courts would have given different verdicts. So that was one of the needs for a codification of statutory GAR in the books. Now, this subjectivity is what inherently was sought to be eliminated. Now, this issue of coexistence was cropping up before the lower courts, and in some of them have actually held that once statutory GAR is there in the books, then JAR is no longer applicable. Now, once the apex court has blessed this coexistence, this again creates an uncertainty from an implementation perspective, and not only to cross-border transaction, but also to domestic ones. Now, let me just take the examples. For example, there's a de minimis threshold of 3 crores in the statutory GAR. There are certain safe harbors. There is a procedural safeguard of matter going through the approving panel. All that is missing in a judge-made GAR or a JAR. Now, if we kind of approve, and as the apex court has done, that means that those safe harbors, those de minimis thresholds, that the whole process of approving panel kind of gets bypassed under the JAR scrutiny. And if that can happen, that perhaps to some extent it does away with the entire rationale for which it was introduced. And more so now with PPT also to be examined in certain treaties where MLI is applicable, where again these safeguards is not there. it creates a bit of uncertainty for taxpayers on what all aspects have to be factored in while working out on their structures going forward. So that is one area of ambiguity which gets created because of this.
Thank you very much, Richa. Pramodji, now I'll be rushing through some questions where I've got a number of questions and very little time. So, Pramodji, the court appears to suggest that the treaty relief cannot result in non-taxation. So, what is your perspective on this? Is this principle, is the principle propounded in the Azadi Bachao case irrelevant now? Very quick
Now
one.
you have to see it from two perspectives. First thing is that post 2020 amendment to Section 90. One of the objects is to avoid non-double taxation also. Look at the MLI. In the post MLI world, certainly what their lordship say hold good. In the post 2020 amendment section of Section 90, what their lordships hold good. So the principle which has been laid down is something which is quite in tune with the way the world is looking at the double non-taxation today. However, the limited point is, can you also apply it in the past cases? What about the situations prevailing prior to 2020? What about situation prevailing in a pre-MLI world? And then when you think of the Azadi Bachao, I'm not really clear as to what exactly was the issue in Azadi Bachao from this perspective. But yes, there is a kind of they have touched a different chord. But then nothing is so final in this world that what you say today remains valid 30 years later. So it doesn't hold good for the modern world. For the modern, the contemporary international tax atmosphere, apprehension is limited to past cases, and that's something which may have to be taken. And then another issue is, does a division bench of the Honorable Supreme Court bind the other division bench? That also I'm not too clear about it. That's an aspect which has to be examined. Because under Article 141, everything binds those who are in the lower tiers. But up there, at that level, is it necessary to refer it to a larger bench? And particularly when it's not the core issue, and it's only an observation, which is a side observation. So those points will have to...
Yeah, you're absolutely right that internationally with the BEPS initiative, everything we are working towards double non-taxation being voted. So I think that is in line. But then, the Supreme Court has formally dealt with the issue of AR maintainability. However, in doing so, it has analyzed treaty provisions, domestic taxability, GAR, and substance. To what extent do principles laid down carry the weight of a binding precedent?
Once again, there are two distinct things. One thing is, what is the role of a precedence? So when you say the question of precedence, when you talk about question of precedence value is of the question which has come up for examination. And Justice Sanjeev Khanna in one of the judgments, Career Education Society, that was in 2023, has been a very brief judgment, but he has beautifully explained which portion is binding and which portion is not. He has recommended inversion test. He has said, if we vacate that observation, would the court still reach the same conclusion? If the answer is yes, then please don't bother about it. And that's not my understanding. That's the understanding of someone in the Honorable Supreme Court. So if I put the inversion test here, following the Career Education Society principle, then I would think anything other than the core issue. And the core issue was whether a TRC simpliciter is good enough for deciding the residency issue. Or one could even narrow it down, whether it was a case of blatant tax evasion or prima facie tax avoidance, in which they should not have entertained the AR. All other things do not have that kind of precedence value. Having said that, I must add that anything which falls from the Honorable Supreme Court is given utmost respect. And those who are in the lower tiers of judiciary would never dare question these kind of things in a hierarchical system of judiciary that we have. Every word which comes from the Honorable Supreme Court is given its due respect and deference. And that's what might happen in this case also. And that's the reason I said some administrative interference may be needed to address some of the issues which are equally concerning to the revenue as they are to the SSC. I'm sure revenue will be concerned about the assurance which the finance minister makes on the floor of the House. I'm sure revenue will be concerned about a situation when they lose rights to tax indirect transfers for those who are in UAE and in Korea or such other places.
Thank you, Pramodji. We are absolutely out of time, but Richa, one question I would just like to ask in small 50 seconds. On the practical, on the ground side, what are your recommendations to your clients at this juncture on the position they should adopt post this ruling?
I think I have two suggestions here. One is, of course, to take stock of your existing structures in light of what the principles have of this judgment have laid down. And just picking up cue from what Pramodji just said, that while the debate is on that what is the ratio here and what is the observation, from a practical perspective, from a tax practitioner's perspective, from an investor perspective, if during the upcoming budget or sometime after, if there could be some guidance given on what will be the parameters, just like in the case of POEM, the POEM cases, what would be those parameters that should be considered for a substance perspective, which will give surety to investors that they are on the right track? What is it that needs to be done on from a TRC standpoint when you're making a remittance outside? What is the additional due diligence that we're required to do? If some guidance can be forthcoming from the government on that, I think that can make the life of a tax practitioner and the taxpayer much easier.
Thank you very much. I think we are completely out of time. If there are any questions, we will only be able to deal with them. We will respond to them by email. So in short, from all this discussion, there are many questions, and a lot of positions will emerge over a period of time. This manufacturing multinationals, GCCs, service companies, this ruling has direct implications on how supply chains, IP ownership, shared service models, holding structures are designed. Where GAR or judicial anti-avoidance principles apply, arrangements that separate value creation from value capture without strong commercial rationale face increased scrutiny. So thank you very much.
Just one small point to add, because
Yes.
people are quite worried about it. On certain points, yes, there are problems. But I would say I have faith in the system, and I'm sure it's a matter of time that these issues will be addressed. There are some problems, there are reasonable apprehension. People shouldn't get panicky about it. There are a couple of problems, and I'm sure these will be addressed. One of the biggest strengths of the present establishment is that they have ears to the ground and they do what is necessary. I don't have slightest doubt that these issues, concerns will be addressed, and this too shall pass. Take it easy. Don't get too panicky.
Great. We shall end on that positive note. Thank you very much, Pramodji. Thank you, Richa. Thank you, Aparna, for a very, very engaging discussion. Thank you.
Thank you. It's a pleasure to be here.